Good morning, ladies and gentlemen. It's absolutely great to see you here. In particular, I think you are coming to Hong Kong at this defining moment of this city, and during the course of truly an upheaval and unprecedented civil campaign in decades that I've seen in Hong Kong. What the events will unfold in the next few days or months or years remain to be seen. Honestly, I don't know, but it's going to be a very important moment in Hong Kong. But during this time, I think it's particularly interesting to talk about the judiciary at this time, because while you're here, you might observe, if you stay a bit longer, you might observe that this is now an angry city. Everybody is angry. Everybody is dissatisfied with the status quo. Everybody is criticizing each other. But it seems that one sector remains uncriticized. No one is willing to point the fingers to this sector, and that is the judiciary. And we're shouting at everybody, but curiously, you see that no one shouts at the judiciary. And it remains to be a respected sector of this city, the ultimate safeguard of the rule of law and the rights and freedoms of this city. So I mean, the judiciary is always an attraction from, in particular, the legal sectors of China, because they just wonder why. I mean, our judiciary could remain intact over years of unrest, upheaval, argument, differences, and they appear to be immune from all the troubles and remain so clean, uncorrupt, and truly credible. If I may start from a general introduction, institutionally, of our judicial system, I've got a very brief chart there, but of course our court system is very simple. You will see that starting from the magistrates' court at the bottom, that of course is the lowest court. It deals with over 90% of the criminal cases of this city, over 90% of the cases. Above the magistrates' court, we have the district court. It sees with both criminal and civil jurisdictions. It deals with more serious criminal offenses, attracting not higher than 7 years imprisonment, which is the district court. It also has its civil jurisdiction, which deals with civil cases involving, in money terms, not over 1 million Hong Kong dollars, which is equivalent to just less than, 130,000 US dollars. And then above the district court, we have the High Court. Now, the High Court, you will see that the High Court has in fact, two tiers. One, we call it the court of first instance. It deals with trial, court hearing. And another part of the High Court is, we call it the court of appeal. Of course, it deals with appeal. It doesn't deal with trial. So this is the High Court. And then our final court is, of course, our court of final appeal, which was formerly the Privy Council of the United Kingdom. So that's basically our court structure. And meanwhile, we have approximately 200 full-time permanent judges in all these levels of courts. I call them a full-time because we do have part-time judges. This is a peculiar feature of Hong Kong. For one thing, majority of the judges were former members of the bar. Of course, we barristers are court lawyers, we are advocates, And most of the judges are appointed from the bar. So members of the bar are going to the judiciary. But of course, before you become a judge, you might think, well, am I a suitable person to be appointed as a judge? I'm not sure. I'm interested, but I'm not sure whether I'm up to it. And quite often, the judiciary will appoint some members of the bar or even solicitors to act as a part-time judge, for example, serving for several weeks or months, and so on. But during this time, you retain your capacity as a practitioner, and after the period of service, you may return to your practice. But of course, after some time, if you decide that, well, I'm prepared to commit myself to the career in the judiciary, then you may apply to become a full-time or permanent judge. So this is how this system works. I think meanwhile we have, well, I don't have a figure. I don't think anyone does, but I think there are probably currently about 20 or no more than 30 members of the legal profession serving as part-time judges. But of course, it serves another purpose. That is, if the judges are, for example, too busy, or some judges are, well, they go on holiday, and sometimes the judiciary find itself a bit thin on the ground. They need some additional manpower. Then they may appoint some part-time judges. So supplement. I mean, therefore, the legal profession supplementing the judiciary. So this is how the system works. So in other words, most of the judges are former legal practitioners, and to turn to members of the judiciary. And of course, to qualify as a judge, each candidate has a minimum of 5 years practice experience, a minimum. But minimum is the absolute minimum. I can tell you, a former pupil of mine is actually going to become a magistrate. He has been serving as a part-time magistrate since February, and he's got only about 6 years practice experience, and he served as a temporary magistrate in the past 9 months, and I think he's proving himself to be up to the job, and he recently tells me that he will be appointed as a permanent magistrate by the end of this year. So a minimum of 5 years. My pupil is an exceptional case, less than 7 years, and he's going to be a permanent magistrate. So yes, so therefore you can see that the judges know the legal profession very well. Talking about the relationship, you know, we all, I mean, in this legal sector, they know us and we know them, and but doesn't mean that their neutrality, their impartiality may be sapped because of this personal relationship. No, we know where to draw the line, and I'm going to tell you later. But I mean, there is of course this kind of mutual or interaction between the legal profession and the judiciary. We know how to work and serve. I mean, and provide our service for the purpose of administering justice. And of course, this is what I will cover in due course. Now, so this is basically the background of the judiciary, the institutional side of the judiciary. And of course, since 1997, since the transfer of sovereignty, the constitutional regime of Hong Kong is based upon what is called the Basic Law. The national constitution does not directly apply to Hong Kong. Hong Kong is based upon what is known as the Basic Law, which is sometimes we call it the mini constitution of Hong Kong. And Article 85 of the Basic Law stipulates that the judiciary will remain independent and will apply the common law and remain independent. In other words, Article 85 of the Basic Law guarantees the independence of the judiciary. But what does it actually mean by judicial independence? Now, this is something that we will have to consider carefully. So that's the institutional side of the judiciary. Now, as to how it works. Now, of course, I begin by saying that independent judiciary is to uphold the rule of law and safeguards individual rights and freedom. And that is, of course, the cornerstone of our society, because everyone is equal before the law. And the impartiality of the judiciary is the best guarantee that the citizens' dispute can be resolved fairly and impartially. Even disputes between a citizen and the government can be resolved in court by a judge who acts without fear or favor. And that is what we call by judicial independence. Judicial independence is not a privilege. We call it a responsibility. It's a responsibility for a judge to act impartially without fear and favor, and demonstrating the highest level of integrity. So in other words, judicial independence encompasses the value of impartiality and integrity. This is how we look at that. But of course, over the years, as I observe the life of our judiciary, one will immediately see that we remain a credible sector in this city, not just because it's a professional sector, but because it has won the respect and credibility from the members of the public here. For one thing, in fact, questions like that have been put to me many, many times whenever I go around giving talks. For example, in China, question put to me like, for example, about the prospect of corruption in the Hong Kong judiciary. And every time my answer to them is that corruption is unheard of in the history of Hong Kong. It's unheard of, let alone some judges being investigated, prosecuted, or found guilty of corruption. So I think we have good reason to believe that it doesn't happen here. But why is corruption absent in Hong Kong? It's an interesting question. It's so interesting that no one is prepared to ask such a question here in Hong Kong, because it can be taken for granted. It has already been taken for granted. The judges are almost immune from corruption. But as I see it, why the judges in Hong Kong could remain clean? Now, I see a number of reasons of that. Number one is that there's no such tradition. We don't have a tradition of corruption. Number two, I think the system is designed in such a way that makes it very difficult for corruption to happen. Now, when you look at our court system, for example, if someone appears before a magistrate for a criminal offense, and of course, if this person is good enough to think of bribing his way to his liberty, he may think of, if I pay some money to the magistrate, then I can buy back my personal liberty. Can he do that? Of course, he might want to do that, but it's very difficult for this to happen here in Hong Kong, because if you want to, go down this way of bribery, you need a middleman. But who's going to be that middleman? There's no middleman in Hong Kong. Between a layman and a judge. The lawyers wouldn't do it. The lawyers never dared even dream of acting as this middleman between his client and also the magistrate. You don't have someone because who can help you. In the course of the court proceeding, no one can communicate with the judge or the magistrate. No one. Usually our magistrate or the judges are very careful about that. They will not allow himself to establish any direct communication. If you want to write to a judge, your letter will not go to the judge or the magistrate. Your letter will go to the clerk or the magistrate. That person will, of course, look at that, and your letter or your form of communication, be it email or written letter, will be vetted by that person before it's placed on the desk of the magistrate. In other words, there is a firewall there. So no one can have a direct contact with the judge, even the lawyers. Sometimes we do write letters to the judges. I mean, in order to propose some, housekeeping matter in a civil case or even a criminal case. We never write to a judge. We'll write to the clerk of the judge. And the judge will, and the clerk will decide whether this should be placed before the judge. Now, this is a practice that has been going on for a long time. So in other words, the system or the practice is such that it's very, very difficult for you to have a direct or indirect communication with the judge in order to, establish, to explore the prospect of corruption. This is number one. Number two, we have, of course, an appeal system. Now, think of a scenario when a magistrate or a judge is bribed and then delivering a judgment or a decision in favor of the person who gives him money, right? What do you think the prosecution or the other side will do? They may or may not know about this bribery. However, the first thing arises in the mind must be to appeal. For a case or a decision, to go on the route of appeal from a magistrate's court, it will go directly to the court of first instance, not the district court. And in the court of first instance, there will be a high court judge sitting there on his own, hearing the case. So in other words, if you want to retain your fruit of success after this bribery, you have to bribe the high court judge. Is it that easy? Of course, it's not easy. You need another middleman. It's far too risky a business. To carry on this corruption exercise. So the system is such that even if you succeed in step number one in paying bribe, step number two will become increasingly risky. But even if you are good enough to bribe the high court judge sitting in the court of first instance, the aggrieved party can continue this route of appeal by bringing this matter to the court of final appeal, from the court of first instance to the court of final appeal. And bear in mind that in the court of final appeal, there are 5 judges sitting there, 5 very experienced, respectable judges sitting there. If you want to remain successful, you really have to bribe 5 judges. And bear in mind that of these 5 judges, at least one of them comes from another jurisdiction, Australia or the UK or New Zealand or Canada. And is it that easy to bribe all of them? And you need only one of the judges who disagrees with this dirty business to give a call to the what we call it the ICAC, the Independent Commission Against Corruption. The whole thing will blow up, and the whole gang will go to jail immediately. As simple as that. So the system is such that it's not easy. For you to even dream of bribing the judge through and get your success in a case. So this is how it works. And besides, I think if you look at this adversarial system in court, you also will find out that it's not easy for you to simply give money to a judge to retain your success in a case. Bear in mind, for example, if you have a trial hearing, you have the judge sitting there, then you have all the witnesses coming to court, and counsel from both sides or advocates from both sides will put questions to the witnesses. The judge will have to hear the evidence and makes his finding of facts, then do the analysis of the evidence, then deliver the judgment. And each judgment has to be in written form. This is the characteristic of a common law jurisdiction. A decision must be handed down in written form. We call it a written judgment. And just think of that. A judge who is to deliver a credible judgment must respect the evidence. He has to do some credible analysis of all the facts. And if he is being influenced, by his receipt of money, do you think that he can I mean, faithfully observe, observe the facts and performs this analysis of the evidence? The answer must be no. It must be very difficult for a dishonest judge, to deliver a credible judgment, and there will be flaws throughout the judgment. We call it the holes everywhere, and it's very, very easy, for the appellate jurisdiction to overturn the judgment. So therefore, you will see that therefore the system is open. It's so open, and it's monitored by counsel, and it's also open to the public, and it's monitored by the public. So therefore, corruption must be out of the way. It's almost impossible for this to succeed here. And of course, there's one factor which some people from some jurisdiction might be interested in, which is about the remuneration of the judges. Well, this is a problem in particular, attracting a lot of debate up in China. These days, the judges have been complaining that their pay has been too low. So low that recently I observed that in some remote regions up in China, some judges complain that, even some rather senior judges complain that the monthly pay is in the region of less than $300 US. Up in some remote regions, which is very, very low, and even in some, higher court in those major cities such as Beijing and Shanghai, it's no more than a few thousand renminbi, which is $600, $700 US a month. So in other words, there is an ample incentive for them to go down this path of corruption. Well, this is perhaps one thing which they have to address in due course. But as far as Hong Kong is concerned, I can tell you, just for your reference, I'm not saying that those people going to the judiciary are because they have an eye on remuneration. They have some value which they want to achieve. But for example, for a permanent magistrate these days, I think the monthly pay is in the region of $12,000 US, 12,000 US a month. And for a high court judge, court of first instance and court of appeal, I think it's probably in the region of close to $30,000 US, plus a fringe benefit, chauffeur, car, accommodation, insurance, children's education allowance, and so on. That guarantees a comfortable life, but it does a month. We're talking a month, not a year. But of course, I don't believe that those who become a judge because they are interested in the remuneration, because here in Hong Kong, the judiciary tends to appoint some really good lawyers, advocates to become a judge. For those who are appointed to the High Court, they are usually generally recognized as successful practitioners. And for those successful practitioners, going to be a judge may mean that they are prepared to reduce their personal income in order to become a judge. In other words, if they remain to be a practitioner, they can earn a lot more money. As simple as that. So, but bear in mind that this is a common law jurisdiction, and the judges make law. And if you deliver some important judgments, we call it leading authorities, they might become the learning material in a law school. In other words, your name will go down the history books. And so to become a judge, you really will influence the development of the law, and that's perhaps the pleasure, the attraction, and the value of becoming a judge. So therefore, for a judge, yes, your remuneration will guarantee a comfortable life, but that's not the whole purpose of becoming a judge, because of this commitment. And but looking at broadly looking at our judge, speaking for myself, I mean, I'm sure many people will share my view that our judges do deserve what they are paid, because you will see that of our 200 permanent judges here, they have been able to show the public that their integrity is up to it. They usually maintain a very low profile, and over the years, we've never heard of any sort of a scandal of a judge. They lead a rather, a decent life, remain low profile. They don't talk easily, particularly in front of the media. And they're clean, and the personal conduct is impeccable, most of them. So I think reputation is to be won. You cannot order people to respect you. You have to win people's respect by behaving in a way that people believe that you deserve it. I think over the years, I think our judges have achieved that. And in particular, also, I think since they are all rather experienced practitioners, so they are rather professional. They know the role of the lawyers, and throughout the years, my experience is that we can interact quite smoothly and with the judge. They understand our work, and we understand the task of the judges. And I think another factor which guarantees the function or the proper function of the judiciary is that in Hong Kong we have a rather robust legal profession, which in fact in the past has been seen to be fighting to preserve the integrity of the judiciary. For example, not long ago, probably 3-4 months ago, there was another march of the lawyers, a march in protest of the intervention from Beijing about the role of the judiciary. There was a march of, I was there, and I think Bijou or maybe Basil, I saw Basil was also there in a march in protest of intervention from Beijing, of our judiciary. And so, in other words, sometimes we see that the legal profession will come out and raise our fist in protest of any intervention of the judiciary. And they remain silent. They will not argue. Even if the judges are criticized because of the judgments are not particularly popular, they will not argue with the public. They will not issue a statement defending himself. No, a judge will never do that. A judge will not defend himself openly. He will only make his view known in his judgment. But after delivering the judgment, if there's any criticism, the judge will not rebut by saying anything. He or she may report to the court leader about a certain matter which gives rise of concern, but he himself will remain silent. He will not argue with the public. But if necessary, sometimes the legal profession will come out to defend the legal profession. I can give you an example. There is a sensitive issue of immigrants from China. Now there's a rule here. For the new immigrants coming from China, they have to remain in this city for up to 7 years before they become a permanent citizen. Now, question immediately arises. When these immigrants come settle in Hong Kong, are they entitled to social benefit? The law is the law, and upon strict interpretation, our Court of Final Appeal says that they are entitled to social welfare. And that judgment is exceedingly unpopular. Many people challenge and questions its reliability. But the law is the law. If this is a judgment delivered by the Court of Final Appeal, then that is the law. So it's very unpopular. So many people across this city criticize the judgment of the Court of Final Appeal. It's a unanimous judgment. But those judges never rebut, never defend themselves openly until the Bar Council issue a statement to the public saying that, please calm down, you have to respect our judges, you have to respect our court. This is our court decision, and this is a court decision. Please don't criticize our judge, because by doing that, by doing that, you are putting at risk that this judicial independence may be harmed. So quite often, our legal profession will come out and make a statement to the public and ask them not to say anything or do anything which may undermine the standing of our court. So therefore, you want to immediately see that the integrity and the independence of our judiciary is supported and assisted also by the legal profession. So this is how we can see over the years that our system works. Now, of course, getting down to the actual practice, our judges know very well that they not only should they remain independent, they have to be seen to be independent. Therefore, the judicial image is essential. To maintain this so-called image of justice, the judges are very careful about their behavior, what they say, and how they act and how they react in the day-to-day running of the court. Now, one thing to preserve the image of independence, impartiality, of integrity is to avoid the image of bias. Now, talking about bias, there may be three types of bias. There may be actual bias, which is rare, but there may be apparent bias, which happens quite often, or the circumstances or development of circumstances giving rise of the risk of bias. And the judges are always very careful about this image of bias. When there is a risk of bias, they will avoid the case. They will send the case to his colleagues, and they say, I'm not going to deal with this. I'll send it away. Well, what is actual bias? Actual bias means that the judge himself has a direct interest, pecuniary or otherwise, in a case. But this is rare. For example, he's having to deal with a case in which he's a shareholder. Well, of course, that must be actual bias. But there may also be apparent bias. For example, I've come across a few times before. For example, when a judge appearing before us saying that, well, one of the witnesses, being a doctor, is a friend of mine or my doctor, and therefore I've decided that I should not act in this case. I should not hear this case. I'm going to send it away. So it always happens in a pre-trial stage or in a pre-trial review. For example, the judge finds that he's acquainted with some of the witness, or he may be seen to have an interest in that, albeit not pecuniary, not money interest. He will say that, okay, in order to avoid bias or to avoid controversy, I'm not going to deal with that. Or sometimes when the circumstances develop that no one knew at the beginning, but subsequently it transpired that maybe the judge may have some conflict of interest with any part of the case. If that happens, most of the time, our judge will tell the parties, now I'm going to tell you, something happens which may give rise of some anxiety about my impartiality, my fairness. So is there any objection that I continue to hear the case? You may let me know and I'll consider. So people, I mean, the parties can express their view, and the judge will consider. But sometimes, although the judge tells everybody about this apparent risk of bias, it doesn't mean that he will be automatically disqualified, because it may be very trivial, minor matters, which will not be harmful in any event. But the appearance of justice is that it should be made known to all the parties. So this is the way we maintain this openness, transparency, avoiding, I mean, any risk of bias. And of course, integrity. Well, I mean, it's self-explanatory. Integrity means that he has to be faithful. He has to know what he's doing, and he has to be honest. And usually this is hardly an issue. I mean, in a court hearing. Well, I can. It reminds me of many years ago. Actually, I personally had a case, which eventually I brought it to the Court of Appeal and succeeded immediately, which is about this apparent bias. I remember that several years ago, I got a case of personal injuries, a damage case, when the fight was actually between the medical experts of two parties. Of course, the claimant, the injured person, the plaintiff, would say that I've suffered very severe injuries and I could not work, and I'm asking for the court to award me a large amount of damage. The other side will say that, no, we do not agree because the injuries were minor and you exaggerated the extent of the injuries, and you do not deserve that high level of damage. Then, of course, both sides will therefore bring their medical experts to the court. Now, of course, I was acting for the plaintiff, and I had my medical expert giving evidence, followed by the defense case. And when the defense expert, the doctor came to court, the counsel for the defense informed the court that, my lord, and that is the qualification of my expert, and so on. Of course, we have to prove that this is truly an expert. This is truly an expert. He had this academic qualification, experience, and he has this special personal credential of dealing with handling this area of medical issues. And when my learned friend was about to inform the court of the qualification of his expert, the judge smiled and said, no need. I know Dr. Chang very well. I have full confidence in his expertise. Oh. He brought himself into trouble. You immediately find out that, and I think he probably regretted having said what he should not have said, because by doing that, he already accepted how we call it, the cogency of this expert. I know him very well. I trust his ability, and I don't need to look at his qualification. In other words, before hearing the evidence, analyzing the evidence of the expert, he already accepted what the evidence of one side. And of course, we not that I lost the case. I got much less than what I asked for, and I took this case to the Court of Appeal. And of course, on appeal, I was acting for the appellant. I stand up in front of the three judges and was prepared to address them. And the three judges said, Mr. Chang, before we hear you, we want to hear your learned friend. They turned to my learned friend. Is there anything from you which you think may justify upholding this judgment? Because this is clearly an appearance of bias. What the judge said, those three statements, clearly show that he was biased, or at least an apparent bias. And of course, my learned friend tried to argue and going nowhere. And in the end, the three judges of the Court of Appeal allowed the appeal, and they ordered a retrial because of this bias, of this appearance of bias. So, I mean, therefore, this image of bias is essential, I mean, in upholding justice, or at least maintaining public confidence in the fairness and impartiality of our court. And this is something that we still maintain, and we're still fighting to protect. Now, of course, I've got another 5 minutes to go, and certainly I will take questions, if you bear with me. Now, I think a moment later, Bijou will no doubt give you, I've got a set of material from a judge's conduct, and which I will not go into details, but if you find it interesting enough, I would invite you to look at that. There are actually many rules of conduct governing how a judge should behave, including, for example, where they should go outside court, and on what occasion they can use the letterhead of the judiciary, and whether they can take part in in any, for example, activities outside court, and whether they can take part in political activities or participate in political organization and so on. There are many very small rules governing their conduct. And when problems arise, how they should react and what they should do, and which I do not want to go into the details, but you can read and you will see that this is how our judges' conduct is being governed by very detailed rules. And well, I think I should stop here, and I've given you a general overview. I'm sure that there will be questions coming up from you, and I think I will leave the rest of time for discussion, if I may. Good questions. It all came out of the blue. And I was slow to react, I have to admit, at the time. But when the judge says, I know Dr. Chang very well, I never doubt his ability. The question is, what does it mean by I know him? I mean it's an unknown quantity. I know him means I met him in a social gathering or for coffee once or twice. But I can tell you that, which I didn't do a moment ago, because I was terribly uncomfortable after the hearing, before judgment was delivered. Because to object may mean that I might be overreacting. I may be seen to be overreacting. You see, a doctor, especially a very experienced doctor in Hong Kong, may be known to many people. So if you would say that, oh, you know him, therefore I object. Well, a judge knows 200 doctors in Hong Kong, then do I object 200 doctors? This is a problem. But I can tell you what happened after the court hearing and before judgment was delivered. I've got some law students and people sitting in court with me. And in fact, one of the students, well, actually, looking back, God helps me. One of the students told me that, oh, Mr. Chang, I think the judge really knows the doctor very well because they apparently come from the same hostel before. I said, how do you know? Because I live in the hospital and I saw the doctor many times. And the judge was also an old boy of the hostel, and they all come to the hostel, the alumni association often. And they always play bridge, all right? I said, really? And when were they there, and were they there in the hostel at the same time? I said, I don't know. I said, go and dig out all the alumni publications of your hostel and investigate. And he went to the university library and dug out the alumni publication back to 1963. So they're very special friends. And I know that the judge was very upset about that. And I'm truly sorry, but I'm duty bound. I mean, to go all the way. I mean, do the best. And 2 years later, I was unlucky enough to go before the same judge again. And when he saw me, he sat there with a long face. I remember the personal story. Okay, now, I have to ask the parties whether there's any objection that I sit here to hear the case. I know he's coming down on me. The other side doesn't understand. He's coming down on me. Because the last thing I want to see is my photo 30 years ago to be put on the appeal bundle. I'm telling you a real story. And my learned friend didn't have a clue. Of course, I know. I said, Your Honor, I have no objection. My learned friend said, nor do I. Okay, we continue. And still the long face was still there all along. Well, anyway, but as I say, not only should a judge act without fear and favor, so should counsel. Even if you're not happy about me personally, I know you're upset, but I'm duty bound to act. But of course, in that case, I respect the judge. I succeeded, not because I'm particularly good, but because, he acts fairly. In the second case. But I'm sorry, he made one stupid mistake before, and I have to go against that, and without fear and favor. So that was it. during the course of a hearing, before judgment is handed down, the media will shy away from criticizing. It will report, but it will not criticize. But if a judgment cannot be criticized, I don't think this is fair. And I don't think that, I think this only happen in a totalitarian country. A judgment must be open for criticism. If the judge says that I am a judge and you are not allowed to criticize me, then what sort of legal system is it? But of course, criticism, there must be a line to be drawn. It should not go beyond the line of harming the judicial independence. So this is, in a civilized society, we know where, how far we should go, where the boundary is. And when, for example, in the social welfare case, the uproar is about opening the floodgate, encouraging new immigrants to flood into Hong Kong, applying for social welfare and undermining the social welfare system. And of course, it upsets many people that, well, we've been working that hard and we have hardly any social welfare. Where these new immigrants who just arrived last week, and they begin, taking advantage of the generosity of our system. Now, the city must allow a debate, including criticism. So if they're not happy, they can appeal. If the judgment, if the government is not happy, the government can appeal, and it has, but they lost in the final court, and that is it. I think the social welfare, comparing the integrity of a justice system and social welfare, I think integrity of a justice system is far more important than social welfare. Social welfare means it's money, but integrity and independence of a judiciary is the core value of the city. So I think people in this city know how wide the boundary is. If you criticize, up to a point. About the financial independence, of course, the remuneration of the judiciary is part of the government budget, public expenses, and it has to be approved by the Legislative Council. So it's not totally in the hand of the administration, of the government. The approval of the judicial expenses must be approved by the and allowed by the Legislative Council. And usually, the tradition is that the Legislative Council will hardly raise any objection to any proposed increase. For example, the increase of the judges' allowance and salary. And often, if the judiciary asks for an increase of the annual expenses, because, well, this year we have to appoint more judges, we want more money. The Legislative Council, I've never heard of any objection from them, because the increase is often very, very modest and justified. So I have hardly heard of any particular, argument about the expenses towards the judiciary in Hong Kong.